Good afternoon, everyone. You're welcome to another Facebook Live session with Loaxin. We're still looking at the new companies and allied matters at 2020. And for the purpose of our discussion, we'll be focusing on non-business organizations for this discussion. We've looked at a couple of amendments that were made to the new one. So today we're focusing basically on non-business organizations. And for the purpose of this discussion, non-business organizations will include Incorporated Trustees and also companies limited by guarantee. Now, the Companies and Allied Matters Act regulates both business organizations and non-business organizations, and the contents of the act they vary across different subjects as regards both categories of organizations. So, even the new a couple of amendments that affect non-business organizations. So we're looking at them briefly, not a lot, but just touch on some of the changes that are like most important ones that we can. Now, corporate trustees are associations that are not even allowed to do business at all, and that is mostly religious organizations that register as incorporated trustees, while companies limited by guarantee are allowed to do just a little kind of business, even though the nature of the business is specifically contained in the act itself. They're allowed to do business, and on the condition that whatever profits they make is put back into furthering the object of that business, or the object of the organization, the object of the organization itself. So we have incorporated trustees and we have companies limited by guarantee. Now, the first change I would like us to look at is the Attorney General's consent, and that really affects companies limited by guarantee. Now, companies limited by guarantee usually require the consent of the Attorney General. Usually require Attorney General's consent for registration of that company. And this used to be a very big problem in these companies because it was like a Herculean task to get the Attorney General's consent, because you have to apply, wait for a period of time. So most people would even prefer to opt out of registering this type of organization. Most times, they would rather try to register a different type of organization rather than register a company limited by guarantee. However, this problem was identified and a provision was made to try to curb this issue. So Section 26 of the CAMA still maintains that for you to register a company limited by guarantee, you still need consent from the Attorney General of the Federation. However, an alternative has been provided in an instance where you cannot get this consent timelessly, where it is becoming difficult for you to get this consent. So CAMA now provides that after you've applied to the Attorney General for consent for a period of time, say 30 days, and you're yet to get a response from the Attorney General, the response could be that there was no denial at all, because if the application was denied, that is the response in itself. So it doesn't necessarily mean that you need to get a positive response. So no response at all could be that it was not denied, it was not approved. It was not even as if they asked you to provide further documentation. So if there's no response at all, it means that you've not gotten any response from the AG's office. So the new CAMA now provides an alternative for promoters of companies limited by guarantee. And the alternative is that if after 30 days they did not get a response from the Attorney General's office, that is, the application was not approved, application was not denied, there was no response asking for further documentation or anything at all, they can then go ahead to publish it in three national dailies, that's newspapers basically. So if you do not get a response from the Attorney General's office, promoters they can go ahead to publish in newspapers and wait for a period of 28 days to get maybe any objection from the public, anything at all. Then CAC can now go ahead with registering the company. So this basically is to help people who wish to register companies limited by guarantee save time. Because like I mentioned earlier, the major issue was a lot of time was being spent on trying to get Attorney General's consent. So the alternative that has been provided is to help curb this excess. Right? So it is a good provision, of course, it is a good law that we hope would further make for ease of registering of companies limited by guarantee. Now, another one will be merger of associations. The CAMA Act 2020, CAMA 2020 now provides that the CAC can merge companies, can merge organizations, we're talking about non-business organizations, can merge associations that have similar trustees, associations that have the same trustees, basically for ease of administration, and also associations that have similar objects, that have similar aims and objectives, can be merged together, subject to terms and conditions and regulations by the Commission. Basically, this provision is to help for ease of administration of associations, and it is also to help with trustees using some of these associations to get properties and all. Basically, to help for regulation of these associations and ease of administration by both the trustees and the Commission itself. But the provision of this section, that's section 284 of CAMA, is still subject to the provision of the FCCPC Act. And this means that even the FCCPC Act itself provides that the content of the Act should be subject to, the content of other acts as regards that provision will be subject to the content of the FCCPC Act, that is ISA, Investment and Securities Act, and CAMA are still subject to this provision of the FCCPC Act. So it means that even though CAMA has given the Commission power to merge some of these associations, or it has given these associations the liberty to apply for a merger, they still need to take into consideration the provisions of the FCCPC Act, basically. So that is what this means. Even though you have the liberty to be merged together, I still need to look beyond what CAMA provides and look at what the FCCPC Act provides, and bearing in mind that the provision of CAMA as regards that particular thing is still subject to the provision of the FCCPC Act. Yeah. So that is basically it for merger. Commission now has power to merge associations that have similar trustees. So it looks at it from two different angles, from the angles of aims and objectives, and from the angle of persons in power or persons in charge of the association. So if you have same set of people in charge of different associations, since they are the same trustees for these associations, then the associations can be merged together to become one. Or if you have two different associations doing the same things, they have the same aims and objectives, they exist to achieve the same things, then these associations can be merged together for the purpose of furthering their aims and objectives. So the new CAMA gives liberty to trustees of associations to apply for a merger, subject to the terms and conditions and regulations provided by the Commission. I'm talking about CAC now. So that's basically it for merger of associations. I remember that I said that while considering merging associations, you also need to take into consideration the provision of the FCCPC Act, because CAMA in this instance is still subject to it, basically. Yeah, so another one I would like us to look at now, and that's the one we really draw on for the purpose of this discussion, is suspension of trustees and appointment of interim managers. Now, this is something that has caused a lot of issue recently. I'd just like us to look at it objectively and try to see what the law actually provides. Now, remember I mentioned that incorporated trustees are non-business organizations, and they basically exist for any other purpose aside from business, and they are mostly registered by, and it's mostly religious organizations that register incorporated trustees. Now, the new CAMA 2020, has given the Commission, that is CAC, power to suspend some trustees on some grounds. Now, I'd like you to understand that this power is not just to suspend them. The power that CAC has is still subject to an order by the court. We'll just look at this extensively, but I just need to state that fact as we go on, you understand better. But this power is still subject to an order by the court, and it's not only CAC, the Commission, that can exercise this power. The members of the association can also exercise this power. So it's provided for in section 839 of CAMA. And what this provides is that the CAC has power to suspend trustees and administration and appoint interim managers to manage the affairs of that association in the stead of the trustee. The Act, however, provides for instances where the Commission may exercise this power. I'll just briefly state them and we'll look at them one after the other. And the first one is where this power may be exercised where the commission reasonably believes. Now we look at that phrase itself. It provides that where the commission reasonably believes that one, there is or has been misconduct or mismanagement in the administration of the association. So it states that where it believes there's been a misconduct or mismanagement of the association. Another one is necessary or desirable for the purpose of protecting the property of the association, securing a proper application for the property of the association towards achieving the objects of the association, the purpose of the association of that property or the property coming to the association, or public interest. And then another ground would be where the commission reasonably believes that the affairs of the association are being run fraudulently. So these are basically three instances that that CAMA provides for. However, these instances are still subject to proper interpretation by not just the commission, by the court also. Because remember I said that they cannot exercise this power. This power itself, basically, is still subject to an order of the court. Now, the law provides how the power may be exercised. So beyond stating the instances where the commission may exercise this power, it now gives a process for exercising this power. So it provides that the trustees shall be suspended by an order of court upon the petition of the commission or members consisting of 1/5 of the association, and the petitioners shall present all reasonable evidence or such evidence as requested by court in respect of the commission. Now, the CAC can, if we rightly interpret this, what this means is that the CAC can only, permit me to use the word, recommend that the trustees be suspended, because it can only bring a petition before the court. It is still subject to an order by the court, and it's still required to adduce evidence in support of its petition. So beyond taking a petition to court, you need to be able to also adduce evidence in support of what you are saying. So the CAC cannot just suspend trustees of an association. It still has to present evidence to the court as regards its petition, and it is still subject to interpretation of the court, and the court coming to a conclusion and giving an order whether or not the trustees should be suspended. And also, this power is not just exercisable by the commission alone. The members of the association can also do this, but however, there has to be like 1/5 quorum that should be met before they can exercise this power. So the commission itself cannot just suspend the trustees. It can only bring a petition for the court and try to adduce evidence in support of this petition, and then the court will now make a ruling on whether or not the trustees should be suspended. Yes. So that is basically what Section 839 of CAMA 2020 provides. So it means that although the commission and the members of the association have power to suspend, there are still conditions precedent, and they cannot by themselves, that is the commission, CAC now, and members of the association cannot by themselves suspend trustees of an association. They still have to take it to court for there to be a ruling upon it. And like I said, there has to be reasonable evidence adduced in support of that petition. And of course, the law of evidence will also apply to the petition. We cannot just take a petition and not, bring evidence to back up what they are trying to petition for. So basically, if we rightly interpret this, it means that the commission does not altogether have the power to suspend the trustees of an association. There are still conditions that are required to be met, and it is only by an order of the court that the trustees of an association can be suspended. I repeat again, it is only by an order of the court that the trustees of the association can be suspended. Now, remember I mentioned that I was going to emphasize on reasonable belief, and I said I was going to come to that. So in subsection 1 of section 839 of CAMA, where it provides that where the commission with reasonable believes that some particular things have been done, 3 instances where I mentioned. Now, reasonable belief itself is still subject to interpretation of the court. If CAC, that is the commission, believes that oh, there's been a misconduct or mismanagement of the association, and then he brings a petition before the court to suspend the trustees of the association, and then tries to adduce evidence in support of this petition. It's still up to the court to interpret, it's still up to the court to make the order, and it's still up to the court to decide whether or not they should be suspended, really. So even in exercising its power of reasonable belief, the CAC is still subject to an order by the court. Now that is basically it for suspension of trustees in association, that is incorporated trustees, really. But then subsection 3 of that section 839 itself still now provides that upon the hearing of the petition and appointment of the interim managers, the court with assistance of the commission, that is CAC now, may make provisions as to the functions to be performed by the interim managers. And so the court and the commission, that is assistance by the commission, will now go ahead to provide maybe the functions to be exercised by the interim manager or managers of the association. Interim managers are people that are appointed to take over the affairs of the association, would perhaps perform the same functions that the trustees should have otherwise performed. And these functions will be spelled out by God in assistance by the commission. That is what section 839, section 3 of CAMA 2020 provides. But however, it also further goes to provide that the functions of the interim manager are under the supervision of the commission. That is, the interim manager is subject to reporting to the commission, that is CAC, is required to report to the commission on the function, how it functions in, or how it functions in the association, that is the Incorporated Trustees, upon suspension of the trustees by another of the court. So I hope you understand now that the CAC by itself does not altogether have the power to suspend trustees of an association. It still exercises this subject and order by the court, that is, it brings a petition, adduces evidence, and then the court rules based on what is before it. And then the end of section 839 now gives a provision that the CAC, the commission, exercising the power, that in exercising its power in section 839, still has to exercise its power subject to the consent by the minister. The minister has to approve whatever it is that CAC wants to do under this section itself. So even all that I've explained, the minister. So I'll just conclude by explaining that from all I've said so far, it is very obvious that the provisions of CAMA really right now as regards non-business organizations are basically trying to make administration of these organizations easier, trying to make these associations be more accountable and be more regulatory compliant. That's like the summary of what the new provisions are in CAMA. That is for these associations to be more regulatory compliant, for them to be more accountable, for ease of administration and regulation by trying to make sure that they can be effectively supervised and they can be effectively regulated by the commission. Yes, that's basically it for our discussion today. I hope you've learned a couple of things from our presentation today. Thank you, and hope you join us for our next Facebook Live next.